we talked about a lot of this already with respect to documents that you should start compiling, things that your agent's going to be looking for, documentation that can move the transaction along. And I know it takes time to dig up some of these materials, so it's better to get a jump on it, right, if you can. If you have a copy of your existing deed of record for the property, we'd like a copy of it, okay? And we don't need originals of any of this stuff, okay? So scan and email is fine, okay? That you can deliver it that way, or you could drop it off at our office. We are located conveniently right off of Wolf Road in Colony, 18 Computer Drive West. Drop things off at your convenience, okay? So the deed, most recent real property and school tax bills or paid receipts if you have them. Now, I know a lot of people escrow, and they say, geez, Brian, I escrow, I don't get those bills. But some banks do, after they pay them, send you a copy of the bill for your records. If you have it, great. If you don't, not the end of the world, we could track that down. If when you purchase the property, if you purchase the owner title insurance policy to protect yourself, we'd like a copy of that. Or perhaps, depending on what county you're in, you may have gotten what's called a 40-year title abstract, which is a big stack of documents that's indexed. So essentially, leading up to your closing date when you purchased, the title searcher would have gone back about 40 years, and any and all documentation that they found on record with the county clerk within that 40-year window, deeds, mortgages, mortgage satisfactions or discharge instruments, judgments, judgment satisfactions, easements, whatever they find, they photocopy it, they put it in chronological order, they index it, and they say, here's your big old stack. This is your search. So if you have that 40-year abstract in your possession, or the owner title insurance policy, then I'd like to get that, okay? And it's particularly important for a seller that resides in a county where you as the seller are on the hook financially for the tax and title search charges. Okay, you'll notice in the contract there'll be a box checked that says, hey, listen, you're on the hook for that. Now, when that box is checked, that doesn't mean that you're paying for the buyer's title insurance. You're not paying for the premium to cover the mortgage policy for the lender, nor the owner policy for the new buyer. But you do need to pay for the tax and title search expense. And if you have the owner policy and or the abstract, now, instead of doing a full 40-year look back, we can come current from the date that you closed on the property until present time, save you some money, okay? So it's important to track that down if you got it. If you have a survey for the property, either you had a survey done for some reason, maybe you had an addition or a deck or a swimming pool or a shed, whatever reason, if you had a survey done, we'd like a copy of it. If you have an older survey that was handed down from the prior owner, we'd like to get a copy of that. If you are an estate, okay, not all sellers are individuals. Perhaps it's coming out of an estate. Then we're going to want to see a copy of the death certificate for the decedent, the person who was entitled, who regrettably passed, and as well as letters, either letters of administration or letters testamentary that were issued by the surrogates court that appointed you, the signatory of the contract on behalf of the seller, as the duly appointed fiduciary to act on behalf of that estate. Okay, if the decedent died intestate, meaning without a will, you would have gotten letters of administration. If they died with a will, letters testamentary. So we need copies of that. If the seller is a trust, and a lot of people have real property for estate planning purposes, which is, again, practice area that we handle, maybe they have an irrevocable or a revocable trust that's the owner of the real property. We need to see a copy of the trust instrument, so we need you to put that forward. Some people are signing contracts on behalf of an individual who's not available or maybe is otherwise incompetent. Maybe somebody's elderly in a assisted care facility and they have memory issues that make them not competent to understand, and therefore they should not be executing legal instruments. But you got a power of attorney in place. We need a copy. If you signed by power of attorney, we need a copy of it, and that original power of attorney if you're signing the deed and other related transfer documents at the closing table, utilizing that power of attorney instrument, we will need the original power of attorney at closing. So just be aware of that. We talked about HOA, the documents that we need there. If you're selling a multifamily property and you have leases in place, you've got tenants, we need copies of written leases, even if the lease has already expired pursuant to their terms. Let's say you said, yeah, Brian, I had a 1-year lease with these people, but they've been here the last 3 years and I never did another lease. They're month to month. Okay, but the law in the state of New York is that they're month to month, albeit subject to the same terms and conditions as were incorporated into the original written lease. So that lease still controls. So I need a copy of it. So I need copies of any leases. Also, if you're in a municipality like the city of Albany, Schenectady, that says, hey, you need residential occupancy permits. We're going to come through and inspect each and every rental unit in the municipality to make sure that there are no issues or concerns, and we'll issue a residential occupancy permit that's good for a set term of years. If that's a requirement in some municipalities, and if so, we need copies of them for each and every rental unit. So we need to make sure we have it. We talked about shared driveways. If there's any easements or encroachments, let's say you've got a deck, either the next door neighbor's deck or your deck that's kind of hanging over the property line, or a shed is over the property boundary line, or maybe you're, unbeknownst to you when you purchased initially, but you're sharing a well or septic that happens to be situated either on your property or next door property with the neighbor or otherwise. Or maybe you have lakefront property and you have an easement or right-of-way for lake access rights, which quite frankly, most buyers, if they can't get to the water, they probably don't want to pay top dollar for that property. So if you have anything like that in place, we need to see the documents. We need to see the easements or right-of-way, whether they're incorporated into your deed or maybe a separate standalone instrument. We need to see them, okay? If you are closing in the winter months, when you close in the winter months, there's certain things that are not going to be able to be inspected by the buyer, right? Swimming pools, central air units, can't look at them, okay? So if you have documentation where you closed out the swimming pool last fall, need to see it, okay? Let's get it. If you have any regular service contracts or recent repairs or anything relative to the AC, let's have it. They tend to give the buyer a comfort level that they're not going to be saddled with some major unknown issue, because they may ask for an escrow until we close, and we don't want to agree that they can hold an escrow for months until they re-inspect these things or have the opportunity to inspect them, next spring. Okay, so it's good to, if you have those documents, it's good to put them forward. If you have solar panels on the property, you have some type of solar agreement in place, whether that's some type of installment purchase contract where you're making payments over time and you own the solar panels, or perhaps you're dealing with a solar company where they continue to have sole ownership over all of the solar equipment and you're just purchasing the power that's generated by the solar panels. Whatever the case may be, we got to see that documentation. You got to find it and you got to put it forward. If you have any executory contracts, what those are is, hey, I'm financing appliances in my home. I purchased the appliance package from Marcel or whoever on credit, and I'm paying it over an extended period of time, and until it's paid in full, they got a lien on the appliances. Or I purchased the furnace or the AC unit, and I'm paying that over time, same thing. Whoever you bought it from, they got a lien on it. We need to see a copy of those contracts. Now, with respect to other issues, be forthcoming with your agent and us, okay? It's very important. So for example, I know some sellers say, oh, I'm embarrassed that I'm upside down on the property, that I think I'm really close here, Brian, for the purchase price, between your fee, the title pickup fee, the real estate commissions, the mortgage payoff. Geez, I don't know if there's going to be enough money on the table to get this all done. If there's any doubt in your mind whatsoever, that that's the case, we need to know that immediately, right out of the gate. You should be sharing those particulars with your agent when you're listing the property, because what probably needs to be done is we need to do a quick deep dive, put together a net sheet, and see what your total payment obligations are. Solicit a payoff letter from your lender and see exactly what you owe. Because if you don't have enough money to meet all of your payment obligations, then you're a short sale candidate, okay? Which means you're asking the seller, hey seller, I know I owe you this much, but can I pay you this much? I need to pay you less than I owe you, okay? And they're gonna do their own appraisal and evaluation, but you need to put together then through the lender's loss mitigation team a short sale package. And they're gonna ask you for the same type of documentation and materials as they asked you when you got approved for the mortgage in the first place. Because at that point they said, hey, we think this person is a good and acceptable risk, that they definitely have sufficient income to make sure the payments are made. But now you're saying, I'm not, it's no longer the case, I can't do it. So they're gonna say, well, let me see a hardship letter. Let's see, tell me what happened. Was it, God forbid, was it an illness? Was it employment, like a layoff? Was it a divorce situation? Why don't you have the financial wherewithal anymore? Hardship letter. And then, oh, by the way, W-2s, pay stubs, tax returns, 1099s, bank statements, the whole nine. Everything you did before, they want to see it all again, okay? And then we have to see if we can get approved to sell it short, okay? And that's somewhat of a lengthy process, so you need to get on it immediately, which is why we need to know, and it may turn off the buyer. The buyer may say, well, then I'm not interested, okay? So it is important to know that. Same if you recently filed bankruptcy. Let's say you're in a Chapter 13 right now, and you're making regular Chapter 13 payments to the standing Chapter 13 trustee each and every month, and you're also continuing to meet your post-petition payment obligations to the mortgagee, the lender, for example. We need to know that, okay? Because you technically can't sell the house without bankruptcy court approval. So there is notice that your bankruptcy counsel will need to put together a motion to the trustee and all creditors. It's usually a minimum of 30 days written notice, could be 20 days on expedited notice, but there's a procedure there, right? It's going to take some time. We need to know that immediately. Same thing, foreclosure. If you are already in foreclosure, the good news is generally foreclosure takes months and months and months. However, it depends on where you are in the process, right? We need to know if you're in foreclosure, because among other things, we would have to solicit a payoff letter directly from the foreclosure attorneys, which includes all of their legal fees and court costs, which the lender is entitled to recoup under the mortgage that you signed way back when, okay? So we need to know what the figures are. We also need to know where you are in the process, because if you're very close to a sale date, God forbid, boy, we need to know that. I mean, realistically, can we accomplish a sale here or not? Okay, so it's critical that we know that. If you have oil or propane in the property, let us know. And we need to know who owns the tanks. Do you own them? Or does the oil or propane servicing concern own them? And if so, who is that? Okay, because that's information that we need to pass along. If you have any security cameras, are they operational, or did you terminate the service? They're there. Hey, if the buyer wants to turn them on, great. If not, they don't have to, okay? So as you can see, and then obviously, if you have a bunch of appliances in the property, when you're cleaning up, you're gathering stuff, if you accumulate a bunch of owner's manuals and warranties on all your appliances, just put them in a nice stack, stick them on the countertop or in a drawer, somewhere where the buyer can have them, because you're just gonna shred them. They'd like to have them, right? So there is a plethora of documentation and materials that you need to start thinking about now and start looking for, putting together, and getting either to myself as your counsel and or to your agent, okay? It's critical. So again, if you want trusted, experienced legal representation, you want responsive, personable service, look no further than the Rohan Law Group PC, because we are your trusted transactional titans.